Welcome to the Immigration Lawyers Podcast. I am your host, John Khosravi. To learn more about the show, please visit www.immigrationlawyerspodcast.com. Please note, this program is informational only and should not be considered legal advice. No attorney-client relationship is created. Please consult an attorney for information specific to your case. Also, this recording is copyrighted. Written permission is required for rebroadcasting. Hello, everyone, and welcome to the Immigration Lawyers Podcast. My name is John Khosravi, and I'm an immigration attorney practicing in Los Angeles, California. The focus of my firm is family, talent, and business-based immigration. You can find more about me at www.jqqlaw.com. Today's show is about the Employment Fifth-Based Preference, aka EB-5 Immigrant Investor Program, that needs to be renewed this September 2015 for the program to continue. The Senate has introduced a bill with all sorts of goodies and not so goodies that we are going to sift through today in our discussion to see how these changes will affect the EB-5 program, clients, investors, regional centers, and immigration lawyers that practice in this area of business-based immigration. To help us learn more about these potential changes, I have invited our special guest, a very talented and experienced business immigration attorney, Ms. Belma Demirovich Chinchoy. Belma's practice focuses on representing businesses and investor entrepreneurs in immigration matters. She has extensive experience guiding foreign entrepreneurs pursuing EB-5, E2, EB-1, and L1 visas. Within the EB-5 field, Ms. Demirovich Chinchoy has developed a subspecialty in direct EB-5 investments and in responding to complex RFEs. Ms. Demirovich Chinchoy has worked on over 200 EB-5 cases. To learn more about Belma, please visit www.eb5plusimmigrationlaw.com. Hi, Belma. How are you doing today?
I'm great. Thank you so much for inviting me. It's a pleasure to be here.
Thank you so much. So the reason we're having this discussion is because of the renewal of the EB-5 program. The renewal is coming at a very critical time because of a lot of issues that have erupted or emerged or been accused against the program. The bill was introduced by Senator Leahy and Grassley, a 79-page document under the title S-1501, the official name of American Job Creation and Investment Promotion Reform Act of 2015. The current EB-5 program is set to expire this September 2015, exactly on September 30th, and the intent is to renew it for another 5 years until 2020. The sensitive political topics I talked about were various investigations and scandals and allegations into behind-the-scenes help from politicians for certain regional centers and investors. The Security and Exchange Commission has gotten involved to cracking down on certain finder's fees that have been used and finders in various countries and in the U.S. for getting investors, which have been giving misinformation and have had conflicts of interest. We've had a new EB-5 director, Mr. Nicholas Colucci, who's been put into place, who's a former Department of Treasury Financial Crimes Enforcement Network, FinCEN Analysis and Liaison Division. There's a reason why they bring someone like that involved, because they're looking for certain things now. There's also the issue of the visa backlog for Chinese investors, which are the bulk participants in the program. And finally, accusations of fraud and terrorist money being used in the EB-5 program. What we discussed today is only the proposed bill, and none of it has gone into law yet. But that's where we're going to get into. Belma, if you could start off by briefly describing what the EB-5 program is and what it isn't, I would appreciate it.
Sure. So in 1990, the Congress created the EB-5 program. The EB-5 stands for Employment-Based Preference, fifth category. And the program is really, its main goal was to stimulate the U.S. economy by encouraging foreign investment. And coupled with that foreign investment, individuals are able to petition the government to pursue permanent residence. It's a two-step process for obtaining residence in the U.S. Individuals are first given a conditional permanent residence, and then if they can demonstrate that their investment has created at least 10 permanent full-time positions for U.S. employees, then the investor may be able to get a permanent residence. So it's really, one of the things we hear about the program when it's portrayed in a negative light is that it's an opportunity for wealthy people to buy a green card or buy citizenship, and that it's really limited to those who want to sort of go under the table. And those are really unfair characterizations of the program. Like you mentioned, there have been a lot of allegations about the misappropriations of the congressional intent, let's say, and also how the program was run. Some of those comments, I think, are well placed, but at the end of the day, the program is not really to purchase immigration status for anyone. It is really to make an investment, see that investment generate economic activity, and as a result of that, create new jobs. No program is perfect, and I think that's why we have this bill in front of us, which I'm really glad that we're talking about it, because it had some really great meat to discuss, and really I think does show that this is not in any way sort of a program that's meant to encourage fraud.
Definitely, and in line with the idea that it's not buying a green card, you got to remember whoever does get a green card through this process becomes a U.S. taxpayer on their global income.
Absolutely.
So for the people who are against this program, they got to remember that these are multi-millionaires to billionaires that are coming here and become U.S. taxpayers. So it's really a net positive for the economy, foreign investment coming in.
For sure. And we're also acquiring talent. A lot of individuals who participate in the EB-5 program are very successful businessmen. And it should also be noted that this is not a program unique to the U.S. Most developed countries have very similar programs and have been known to use foreign direct investment in their immigration programs to both encourage investment but also to stimulate the economy.
Yeah. It's definitely one of the more difficult programs.
Yes.
Some other countries have programs where you just buy bonds, which is much safer.
Absolutely.
Here you got to create 10 full-time jobs, which is not a joke in the regulatory environment and the business environment the U.S. is in.
Yeah.
Okay,
sure.
so let's get down to the details of the bill. We're just going to go through one by one. One of the first things that's been changed, has been clearly designated, is that administrative fees must be sourced now. This is an issue I've had in the past, and we've both received RFEs. They've been much more clear that you need to actually source not only the investment funds that are coming in, but also the administrative fee that each regional center charges, which could vary from 20 to 50,000 or whatever. It's important that they actually put that in there this time and require us to do that without any regulation. The next one is about tax returns. Could you talk a little bit about that?
So in the area of source of funds, which you just mentioned you just mentioned the administrative fees. So one of the requirements for the participation in the EB-5 program is to source all of the funds that are being invested. Like you said, previously the admin fee was not considered part of the investment, so we didn't necessarily have to source it, but USCIS changed its policy, and now it's clear we have to source it. So the other part of source of funds that is now changed, and I would argue has become more rigorous, is the requirement that investors provide up to 7 years worth of tax returns in their home country or wherever it is that they're filing their tax returns, and that's become a mandatory part of their source of funds. Now that, of course, is problematic for a lot of our investors who live in countries that don't have a federal taxation system and don't require filing of taxes. Or, for example, in China, where most of the EB-5 investors come from, there is no such thing as an individual income tax that's paid separately from the one that the employer pays on behalf of the employee. So it's a very different tax system, and I think this is one of the points that EB-5 lobby is going to probably come out very strong on, because this would really eliminate a lot of our investors. But also, in many instances, taxes are not relevant to the source of funds when the funds are coming from, say, inheritance or a gift or appreciated property. So tax does not necessarily need to be a part of everyone's source of funds.
Yeah, that's one issue when they're drawing up these regulations. They have the expectation that the whole world has the same kind of bureaucracy, expectation, and standards that the U.S. has, which is not the case. That's why the people are investing to get out of those countries to come here.
Very true.
So, in line with the source of funds, now we're seeing the necessity to identify intermediaries that help in the transfer of the funds, which could be potentially more work. We spoke about how you already do that with your Chinese clients. For me, it's a little more difficult from Iran because it's a more unofficial system, and a lot of times they don't want to be identified. And we have all sorts of difficulties as it is just tracing the source of funds. Now we have to get third-party individuals involved to identify themselves. That's going to make things a little more difficult. Another restriction that's been cutting down is the restriction on gifts. This was a good way to be able to prove source of funds, but now they've cracked down on it, and it's much more stringent. If you can talk about the new gift requirements.
Absolutely. So the regulation proposes limiting gifts to only the immediate relatives, essentially, as they are defined by immigration, and also siblings and spouses. So Currently, there is really no, your employer could give you a gift if the employer chose to do that. Of course, as an immigration practitioner, we would probably want to address that. Why would someone who's not related to you or married to you, I guess, related by law or by blood, would want to give you a substantial gift of, say, $500,000 or $600,000. So, but the regulation now says that even if you wanted to, if this regulation were to go into effect, it would say that you can't. You have to get the gift either from parent or grandparent, your sibling, or a spouse.
Yeah. And they're going to have to use source of funds for how they got the money as well. So that's still a source of funds doesn't go away. It's just a bigger headache these restrictions are adding. The use of loans as a source of funds was an interesting way to do it as well. And they've created some more restrictions on that. I'm not sure how difficult it's going to be. There is the restriction that I think it's already in the books, that when you loan money, it has to be on personal assets. Mm-hmm. It can't be unsecured debt. But now they request that the bank loaning you the money must be a reputable bank or a licensed lending institution. So it can't be borrowing from a friend. Right. You got to have a legitimate bank and be able to prove that.
Yeah, and I think that'll be heavily debated before this bill or any of its parts go into effect, partly because it is very unclear as of right now when this determination is going to be made. It says that the Department of Homeland Security would make the decision as to what is considered a reputable bank or a legitimate lending institution, but we don't necessarily have guidelines of that, and it makes it very difficult to practice this area of law. But also, it seems unrealistic to expect the USCIS, or the Department of Homeland Security, to evaluate every single lending institution in every single country. So it sort of from a practical standpoint, this is very difficult. And the way the language of the proposed bill is drafted right now, it also suggests that USCIS may retroactively decide the institution that you secured your funds from was not a reputable institution, wow, which would create really significant and unfair scenarios for a lot of the investors. Yeah, absolutely. So this is, I would definitely see this as being one of the areas that a lot more clarification would be needed, and the USCIS may decide, well, wait a minute, we can't really, we're not in this kind of work. Perhaps it would just be, something along the lines of, if going back to the OFAC regulations, if it's listed on the OFAC list, you cannot use it, yeah, and things like that.
I mean, I've had problems in another area of EB-1 proving that a person worked at a reputable company, and I've had companies that are multi-billion-dollar international companies, and they RFE me not accepting that this is an established company that the person's working at as an executive or whatever. And so, you just already know that there's going to be some problems in accepting them. So there is some more interesting stuff that has happened with regards to regional centers. Actually, one of the key aspects of the program's change, which is much talked about, is the change to the investment amount. Could you talk about that? The current investment amounts are $500,000 for a TEA, designated areas of high unemployment or rural areas, but they're increasing that potentially to $800,000. And also the $1 million goes to, is that 1.2, am I correct?
Yeah. Yeah.
So that it might scare off some people, it might not. It does change the game.
So this is, an eagerly awaited proposal, because everyone in the industry has been talking about this being very likely change in the EB-5 program in 2015. Program has been around, like I said, since 1990, and dollar amounts have not changed since then. So that's an exceptionally long period of time. And if you were to compare the adjusted this amount of investment adjusted for inflation, we're really talking about very different numbers. So $800,000, like you said, would be for the targeted employment areas, meaning high unemployment areas, and then $1.2 million would be for everywhere else. So it's geography dependent, and we'll see. I mean, I think $800,000 and $1.2 million are still very comparable or competitive investment amounts, and I don't necessarily think that this would have a huge impact on the demand of the program. I wonder if Immigration and Department of Homeland Security is hoping that this would maybe help with the visa backlogs a little bit, but I don't necessarily think that's going to happen. But either way, I think everyone's really expecting the dollar amounts to go up.
It kind of makes sense. I mean, to have these dollar amounts right now, Los Angeles City or County proposed a minimum wage hike that's much more expensive. When you calculate how much expenses are today, 500,000 might not create 10 full-time jobs.
Absolutely.
I think it creates more legitimacy to the system to have more investment coming in. For the investor to know the company has the potential of making 10 full-time jobs. With 500,000, I mean, they really got to have, with expenses and the inflation, some really good plans to do something like that.
Well, the idea is that the $500,000 would not create 10 jobs, but it would create enough in economic activity that would then result in 10 jobs. But like you're right, the starting up a company at $500,000 is difficult. So for direct EB-5 investments, we see most of our direct, at least most of my direct EB-5 investors end up putting more money than $500,000 because you can't do a whole lot with $500K.
Yeah, when people call me about direct, I say, don't look for anything less than $1 million. Like you don't want to blow your money and waste it and then not get the green card and then have to go back to your country and have this thing here. With that, the TEA idea, we describe what it is. There are some additional things they added. One is they're including closed military bases, or they like to include closed military bases as a TEA area, or that is redundant, but TEA. The duration of any TEA designated area will be for 2 years, renewable for 2 years. But they also have a requirement that 50% of the jobs that are created, if you designate yourself in a TEA area, to be created in that area. So it's much more restrictive. There's been possibly a practice by some regional centers to get the TA designation and then create a lot of jobs outside that area. But it seems like they're cracking down on how it's designated and how much of the jobs are created. So that's going to be interesting. This
is kind of an advanced EB-5 topic. So basically what this means is that the economic reports that a business would submit as part of their EB-5 petition are going to have to address to a much greater level the job creation. So there's something called the commuting pattern analysis that economic reports look at. And what that really means is that economists look at geography of the proposed job location, and then they look at where do the employees for this particular location come from. And then they do an analysis, claiming that you're going to draw upon such and such counties or such and such cities in order to get your employees. And so with the new requirement, your economic report is going to have to show that your employees would be actually coming from areas that are also TEA. So what that means is that you're probably going to have a pretty hard time, getting TEAs in highly urban areas, because you won't be able, even if you can get a TEA designation based on a single census tract, you're going to have a very hard time showing that your employees are coming from TEA areas if your TEA is surrounded by all low unemployment areas. Anyway, I'm sorry, it's kind of complicated, but like I said, it's an advanced topic for sure. Yeah. But the brief of it is that this is going to put additional requirements on the econ reports that are going to have to show where the jobs, where the employees are coming from.
And right now, the removal of conditions phase has taken a year. It went from being the fast part of the process to just as much that 526.
Correct.
This issue is going to create even more backlog unless they hire more people and increase the fees, which we'll get into.
And of course, this would be a 526 issue, though, because you won't be able to get an approval unless your econ report demonstrates it. Now, later on, at 829 stage, you're not looking at W2s.
They wouldn't look at W-2s or where the person is?
No, because if you have an econ report, that pretty much means you're doing an indirect.
Oh, yeah, I keep thinking about direct. That's true.
So direct would absolutely. I mean, direct would have to face the same requirement, and in a direct sense, then you would really have to show where your employees are coming from based on the W-2s. And
so it seems like the regional center investment model is still going to dominate just based on restrictions alone.
Well, even if we look at the proposed bill, there isn't a single word mentioning the direct EB-5 investments. It's really geared almost entirely towards the regional center. And part of that is that's where everyone perceives regional center program to be more problematic, and it's where 90% of investments go into. So it makes sense.
Well, in line with that business plan we spoke about, they're really cracking down on how the exemplar looks like. It's mandatory now. They want it to be mandatory to have an exemplar. They are adding a premium processing for that, which is very helpful. But could you talk about what this exemplar needs and what's going to include it?
So yes, one of the big proposed changes is that each project is going to have to file an exemplar application. Now this, of course, is limited to regional centers that run more than one project, and up to right now, I would say less than half of regional centers filed exemplar applications because it was an added step that was not required, although it had a lot of perks once you did it. But the proposed law says you have to file an exemplar application, and not only that, but the proposed law would introduce several additional requirements. For example, they would have to show evidence of providing of documents that were filed with the SEC. We don't exactly know what that means yet, whether SEC filing will be required for every single offering, but that's definitely to be determined at a later date. Also, regional centers would have to provide a certified statement regarding potential conflicts of interest among the regional center, the new commercial enterprise, the job-creating entity, or principals of any of these entities. This is one of the areas that has been under a lot of scrutiny because individuals in the Congress and in the community in general have said that this is very, very much where the fraud occurs, and there's a lot of self-dealing going on and a potential misuse of funds, and we definitely saw that in some of the litigation that took place in regional centers. In addition, the proposed regulation requires that each person who's going to be involved with the regional center and potentially or reasonably likely to receive fees or transaction-based compensation in connection with the investment would essentially have to be disclosed. Their name and contact info would have to be provided. So an important note here is that immigration attorneys who are practicing properly would be excluded from this because immigration attorneys should not be receiving fees or transaction-based compensation.
Which is what they've been cracking down on.
Absolutely, yeah. And finally, the requirement is that regional centers must have policies and procedures in place that address how everyone who is involved with this regional center is in compliance with the law. So, would that be SEC or just general EB-5 compliance? And so this would apply to immigration attorneys. However, as long as the immigration attorney sticks to her or his job and advises regarding immigration and doesn't necessarily go onto the deal side and the offering side, then they would be in compliance. And finally, there's going to have to be a certification that each person who is, and I quote, in active concert, end quote, with the regional center is in compliance with SEC in connection with the offer. This also creates a lot of questions regarding the agents and finders who are located abroad, who are not under the SEC jurisdiction, but this would essentially extend the jurisdiction to them. So this is an area that I think we will see a lot of debate on, and most likely the final bill that gets signed into law would look very different from what's here.
Yeah, this could be a game changer, matter of effect, especially in China. There's a whole economic environment system created around EB-5, and there's a lot of money going around that could be affected by this.
Absolutely.
Just in general, the regional centers do bear the brunt of the changes in this program, and it affects them. I mean, just the basics with the job creation requirement. If you could talk about the indirect job creation regarding the new numbers that have come out, the 90%, 10% issue.
So in EB-5, just as a way of providing some background, there are three types of jobs one can receive credit for, an investor can receive credit for in creating, and those are direct jobs. One could look at those as being W-2 employees, but they can also be interpreted a little differently under the economic models. But then we also have indirect and induced jobs. So there are also scenarios where a project has a capital stack that involves both EB-5 funds and non-EB-5 funds. Up to right now, basically currently, EB-5 investors can receive credit for all jobs created by a project, regardless of what funds create those jobs. So if the project is going to create in total of 100 jobs, all of those jobs will be credited towards EB-5 investors, even if investors only make up 20% of the capital stack. So that is proposed to be changed. So currently, the Congress is proposing a limit, rather the senators are proposing a limit on jobs created by EB-5 investment.
Well, let's talk about the first one where 90% of jobs can be indirect, but 10% have to be directly created. So a regional center can't completely use an economic model. They have to have some W-2s, as you said, or variances of that. But then it comes to the more complicated part of using non-alien funds. So these are not immigrants. They're additional investors in the program. Before, any money that they invested will be included as the job creation. But now they're restricting that, putting a ceiling on that, which actually could really change things. It's a little harsh measure. I think it's a little too harsh. But if you could cite an example of how that works, it's a little confusing. So what would an example be of how this 30% job creation would work?
So the jobs that are created by non-EB-5 investors cannot exceed more than 30% or the percentage of the funds that are non-EB-5 funds. So by way of example, if the total budget of a project is 20 million and 15 million are EB-5 funds and 5 million are non-EB-5 funds, so we see that 25% of the capital stack are non-EB-5 funds, that 25% will then serve as our limit, meaning that no more than 25% of the jobs attributed to EB-5 investors can be created by non-EB-5 funds. So in this particular scenario, for example, if each $1 million created 14 jobs, then you would have, $15 million in EB-5 funds would create 210 jobs. $5 million of non-EB-5 funds would create 70 jobs. So for total job creation of 280. Now, 25% of 280 is 70 jobs. So in this case, because we are under the 30% firm threshold, and we're also at the threshold of 25%, which is the percentage of non-EB-5 funds, all of the 70 jobs could be attributed to EB-5 investors. But a different example would be where you have, say, 40% of the capital is non-EB-5 funds. In that case, even if 40% of the jobs are created by non-EB-5 funds, the number of jobs be limited to 30% of the total job creation. So this comes into play with large regional center projects where the capital stack, of course, has to be very diverse, especially where we have land transactions. In almost all EB-5 cases, the land will be owned by the project principal, the company that owns the regional center, for example, but that land value will be considered their contribution to the project budget. So this is going to be a problem. If you value your project budget as having a large percentage of principal equity, you're going to run into the problem of the job creation. Now, why would one do that? Well, because to make the project easier to sell, you want to tell EB-5 investors, well, we have a very diverse capital stack, and EB-5 investors only make up 30% of our capital stack, which sounds very attractive because as an investor, you would think, well, I'm putting in money with other people. If other people think this is a good project to invest in, then it's probably a decent project. So they feel safer investing in projects that have a diverse capital stack and that have a small percent of the overall funds coming from EB-5. That's going to change because the smaller the percentage of the EB-5 funds is, the smaller percentage of jobs you can claim. So it's going to change how we create project budgets.
I mean, it's unfortunate because it really helps the legitimacy of this program to know that it's not just all EB-5 investor money. That could potentially look like a scam of just trying to milk foreigners for their money and creating a project that you don't know. If you have like a group of people that also want to invest and put a bulk of the money, that actually helps the program and helps the whole system. So it's unfortunate that these kind of tough restrictions are coming up in this place.
And also just to add to that, I think it's counter towards the original intent of the program. The program is to stimulate the economy and create jobs.
Exactly.
So if we need to infuse some foreign investor money to make this project feasible, then why put a limit on it? It's really it's counter what the original intent is, and I think this was probably going to be again subject of hot debate on the congressional floor.
As confusing as they've
As
made
it is, yeah, I know.
In general, they're cracking down really hard on the regional centers. DHS will be getting expanded powers to control certification, removing certification, control of members, who's allowed to be a part, background checks. Can you talk about generally about the hardcore security stance that's been taken because of fears of terrorism alone, money laundering, and all the other issues that come when Department of Homeland Security comes into place for these things?
Sure. I mean, all of the Department of Homeland Security programs always have the anti-terrorism provision, which I think is understanding, national security and terrorism. But what's really striking about the proposed bill is that there is going to be a lot more scrutiny of individuals who engage in the EB-5 program. So the principals and individuals who have high, sort of like a decision-making authority or ability to directly influence how the funds are spent, those individuals in a regional center or in a project that's sponsored by a regional center will be highly scrutinized. First of all, no one who does not have a permanent status in the U.S., meaning a green card or a citizenship, will be able to be a principal of a regional center. That's one of the big proposed changes. Then individuals that do have these decision-making authorities or substantive authorities will be subjected to background checks, FBI checks. They would have to be fingerprinted, which is fairly. One would say it's fairly invasive. I mean, we don't require that of people who run typical jobs right now. Of course, if you have criminal background of a certain degree, then you are limited to some sort of participation in certain programs. But this is pretty extreme. In addition, what's very striking is that the Department of Homeland Security, the director would have a very uninhibited authority to remove individuals from participating in a program, to suspend individuals from participating in a program, to put in all sorts of regulations and limits. And one of the things that's really striking is because the bill proposes that this is unreviewable authority by the director.
It's very strong language.
It's very strong language. It's very counter to, I think, how we want to create programs.
It's going to scare off regional center programs. Why bother? Yeah.
Again, I think I understand that this bill is proposed in reaction to some of the really bad press, but I think everyone would agree that we shouldn't be creating bills based upon a couple of bad instances. I think those should inform our thinking, but they should not be what we react to and how we craft our laws. And I think this language is exceptionally strong. And also, it's really important to note that for immigration attorneys who are affiliated with regional centers, as in represent regional centers or represent projects of regional centers, we too will be subject to some of this scrutiny and would have to all of our details would have to be disclosed at the very, very beginning, which is true in many cases right now. But different sort of sanctions would apply right now. The bill proposes gradual sanctions for deemed violations of the program, and that includes legal representatives, immigration attorneys.
I mean, these sanctions have a lot of teeth. There's civil, monetary penalties, temporary suspension from participation in the program, permanent bar from the participation in the program for one or more individuals, and even termination of the regional center status.
Absolutely.
They've also established a new EB-5 integrity fund, which will require a $20,000 annual regional center fee, which I think is going to cut the number of regional centers by a large. I would maybe say 70-80%, and a lot of them just have the designation without using it.
Yeah, I think that's definitely another change. It's now going to be more expensive to run a regional center, and regional centers that do not have any economic activity will find it that much more difficult to maintain their designation. But what's very interesting about that fee is that it funds the site visits.
Yes, the site visits.
Sound great.
They've started site visits for L1s, or just Ls, intercompany transfers. Now they're moving that to EB-5, so that's always a fun thing.
Yeah, and sounds like every regional center, or rather a project, it will receive a site visit, at least one site visit per year. They can be announced or unannounced. But what I find, and to be honest with you, like I feel like I welcome that.
Yeah.
I think if we have more opportunity to interact with the director and its staff, they would understand the project and the EB-5 program a lot better. I mean, they see it in this vacuum, and they see it in this media portrayed way, really. But at the end of the day, these are businesses. There's nothing really unusual about what happens on sort of on the non-immigration side of an EB-5 project. And so I think that I really welcome the opportunity to have some time to discuss the project. And the bill did propose that site visits would be an opportunity to discuss any potential areas of misunderstanding or any potential concerns that immigration may have, and to be able to cure any deficiencies that immigration may have. So, right now, a regional center may have a phone call with the immigration program if there's an RFE or a notice of intent to deny, and that I think has also been really successful. It just gives you a chance to discuss exactly and is the perceived issue, and have some face time with the adjudicating officer. So I always encourage regional centers that should you get a RFE or annoyed, we should jump on that opportunity and go visit them, or have a phone call at least to really discuss the problems. Yeah.
You just have to prepare your clients, if they're a regional center, for this, so they're familiar with the package. If they come there, they can know the answers. I know for my Ls, I send a copy of the package and have that on site, and make sure they know what's in there, so when they're questioned about stuff, they don't say something that's contradictory, just out of their lack of knowledge.
Yeah, absolutely. I mean, I think this provision itself too might, increase the professional level of regional center principals, because I think up until now we've seen really, just a great range of high-end professionals, business people, developers who run regional centers, and then individuals who just establish regional centers because they know 2 or 3 people who want to invest, and they thought it was a good way to do it, but they don't actually know anything about running a business here. So this will,
Yeah, what you said is really important. It does make it more restrictive to have a regional center, but it brings the standards higher. As it is right now, if you have the money to request the regional center certification, you could do it.
Right.
And clients always ask me, which one's the best one? And there's so many of them. I'm like, well, most of them just have it, and the standards aren't high. It doesn't mean USCIS has done some background checks or anything like that. It makes it easier to tell your clients that there's been background checks to these people, so they're not criminals. We know that at the very least, and that alone will satisfy people that are overseas, that are investing a large sum of money and send their family here. Absolutely. One of the interesting things that's come about, and I'm kind of happy they did this because it gives people the opportunity to continue their investment, is if the regional center is terminated for some reason, giving opportunity for the investor to continue to have their temporary green card or conditional green card and redo their investment. Could you talk more about that, Belma?
Sure. Because so much of this proposed bill focuses on really curtailing the regional center's ability to practice, and termination seems very possible in many cases. Sure. The proposed bill also talks about what happens to the investor. So if you are a conditional permanent resident and the project in which you invested or the regional center that sponsored it is terminated for lack of compliance with either SEC or EB-5 law, presumably, then investors are given 180 days to figure out what they want to do, and they're given some options. So one option is that they can invest in, if the termination is to the project, not to the regional center, then the investor has the ability to invest in a different project within that regional center and continue his conditional permanent resident status. Now, of course, this leaves a big question mark. What does this mean? It's going to play out really. Well, if the regional center project is terminated, does this project have any money to refund to investors, principal investment, which they can then invest? Or is this really basically saying, well, you just have to come up with another $500,000 or $800,000 to invest in a different project? And then they also says that if it's the regional center that's terminated, then the investor has the right to invest in a completely different project. This is not really different from what we have right now. We know that in cases where regional centers did not do well, the projects did not do well. We've often seen litigation by the investors, and USCIS continues to extend their conditional permanent status while the litigation is pending. And of course, our court systems are very backlogged, so litigation is several years, multiple years for sure. Also, we know that there is a large group of investors whose conditional status is expired in early 2000s, but there's litigation about job creation, and those individuals have been conditional residents since then. It's been over 15 years.
Wow.
So I don't necessarily think this is sort of a big change. You know, what's the real significance is the focus on terminations. You know, they're really tipping us off that terminations are going to become much more commonplace in the program.
Mm-hmm. Yeah, it's a warning of things to come. And in that line, they're also adjusting the filing fees and the timelines. If you could talk about those adjustments that have been proposed.
Mm-hmm. So we know that as of right now, the 526 petitions are 1,500 filing fee, and the petition to remove conditions is $3,750. So in an immigration sort of in a grand scheme of immigration fees, these are fairly high. However, in the EB-5 world, they're not necessarily high amounts of money. But what's more important is that the senators here are making a direct link between the processing time and the filing fee. And what the senators are proposing is that the Department of Homeland Security conduct a study to figure out how much money do they need to collect at a filing fee stage in order to be able to achieve certain processing timeframes. And the exemplar processing timeframes are 4 months, 120 days for regional center and exemplar applications, 5 months or 150 days for a 526 investor petition. And just for a point of reference, it takes 3 times as long right now.
Yeah.
We're looking at 15 months approximately.
I mean, they say 12 or something like that, but that's not the real case.
Right, we have not seen 12 in a long time. And then also 6 months or 180 days for removal of conditions petition. And so again, the important thing is that the Congress here is saying, or the senators are saying, run this like a business. Figure out how many people you need to hire, how much you need to pay them to be able to process these petitions within a specific amount of time so that you cover your costs. You don't need to be profitable, you're a government service, but run it like a business and be accountable for what you are telling your clients. So it would be great to see this, and I don't think anyone can argue with this approach as long as we don't see our clients paying $10,000 for a filing fee and then still waiting for 18 months for adjudication.
So another new part that's interesting is allowing people to do removal of conditions even before they arrive in the country. If you could talk about that.
Sure. So what the proposed bill says is that if an investor can demonstrate that they have sustained their investment for 24 months from the date of investment, they are eligible to apply for removal of conditions, assuming that jobs have been created and they can actually demonstrate eligibility. But the key here is that you have to wait only 2 years to file for removal of conditions, and that is not dependent upon your status of how long you've had the conditional permanent status. So in some cases, it's conceivable that somebody who has never received a conditional permanent residence would apply to remove the condition on that residence. And how this would play out is that for somebody who's from China who petitions for EB-5 and is caught in retrogression, that individual is not going to receive their conditional green card within a 24-month period from their investment. As I mentioned, it currently takes 15 months to process the 526 petition, and then it takes at least a year to go through the consular process for immigrant visa. So at a minimum, they're looking at 2.5 years from the time they invested to enter the U.S., much less receive the green card. So This would be a provision to address that really long time period after the investment, and it would allow investors to come into the country much sooner.
That's be welcomed. I know Chinese are going to like that a lot, as well as another provision they added, which is concurrent filing, allowing people to do adjustment of status or I-45 applications along with the I-526 if they're already in the U.S.
Absolutely.
So that's if their visa is available. So it wouldn't come into play for Chinese investors, but for a lot of people that maybe, a lot of my clientele have had the issue of being students here and then their parents give them the money for EB-5, they could continue being student here and adjust status, or potentially if they came here on a tourist visa and decided later on to change their intent, they could do that and stay in the U.S. and not have to go back home, or potentially get advanced parole and be able to travel back and forth and still have their residence here while the process is going forward.
Absolutely. I mean, this is a very interesting and, like you said, welcomed change. You know, it makes it sort of more similar to marriage-based petitions, where, and it's important to remember that the investors would still be applying for a conditional permanent residence. They would not be applying for a permanent residence, and they would still have to demonstrate a job creation. So this is just giving them an opportunity to come in to the country earlier, or as you said, adjust status. And I think this provision specifically would be very welcomed by all direct EB-5 investors. Many of my clients have struggled to maintain their businesses in the U.S. when they haven't been able to enter and manage their business. So this, I think, really speaks to that direct EB-5 side. Now, of course, it conditions it upon visa being available, which would exclude the majority of our clients, but it is a step in the right direction. And I just wanted to add, too, the provision that allows for the filing of petition to remove conditions. That provision does not at all talk about the visa availability, because it's conceivable that someone has not received their conditional green card within a 2-year period after their investment because the visa is not available. Now, I would imagine that those individuals would not be able to file for 829 to remove the conditions because they still don't have the initial visa number. So you would have to meet both requirements. At least that's my reading of it, is that visa has to be available and it's been 2 years since your investment.
Well, that's true, because you can't give a green card if the visa's not available.
Exactly. So it's an important note that it's not made clear in the bill, but I cannot imagine it working out any differently, because you would be then really jumping the line, as they would say.
Although according to the most recent visa bulletin, I think there was a 6-month jump in the EB-5 time for a Chinese investor, Chinese EB-5 category preference.
It's a 4-month jump to September 1st.
Okay.
And we're hoping that it's going to continue advancing, and speculations from Charlie Oppenheimer, November is where we're likely going to end up, which is a nice advancement from May to November. It's 6 months.
So it's less scary, at least they're hopefully making it less scary for the Chinese investors.
Absolutely.
Okay, so that covers all the proposed changes, or most of them. In review of it, I think it is a step in the right direction into giving more legitimacy to the program. I would like my clients to have more comfort in the company they're doing, and knowing that there's some sort of background checks or some sort of investigations required by USCIS is a positive thing. But definitely some parts of these have to go. It's way too restrictive, way too confusing, and then it opens up just a whole new mess of problems that we don't know or understand, and USCIS isn't. And already the RFEs we get are difficult enough as it is. If they're trying to fix some, but with this bill, they're going to create a bunch of other ones. So there definitely needs to be more work, and the House needs to look this over, and the lobby needs to get involved. What are your thoughts about the program proposal?
Yeah, I think, like you mentioned, a lot of welcomed suggestions. I would definitely like to see most of the language not make it into the law, because it is very restrictive, and as I mentioned earlier, this law, the proposed bill, really seems to be reacting to the negative portrayal of the EB-5 program. But it is a starting point. We like to see the program authorized to more than 3 years, so the reauthorization to 5 years is great. We also, I personally like some of the regulations that would make the program a little bit easier for investors in terms of being able to file concurrently potentially, or filing for removal of conditions sooner. But most of the language is very harsh and not practical. But what this means is that now it's the time for the EB-5 industry to engage with our congressional representatives and educate them about the ways these proposed changes would make the program unworkable. That's nobody's goal, really. I'm pretty sure of that. We understand the Congress wants to put certain limits in place and provide structures so they could have a better oversight of the program. We welcome that. I think that's their job. They need to do their job, but they also need to let us do our job by providing a law that provides clear structure within which the program can operate, and not just sort of very restrictive language that's not practical.
Yeah. One thing I tell people who want to learn about EB-5 when they come to my office, new attorneys or interns and clerks, is EB-5, you have to do it to learn it. It's not something, the regulations the way they are, it's not something you can just pick up a book or a guide.
Unfortunately, that's, I think, the case with a lot of immigration.
Yeah.
And you know, anecdotally speaking, it is one of the things that our clients find so fascinating about our practice of immigration law. When a client asks me, and this happens a lot, well, what does the law say about this? And I would say, well, we don't know. It doesn't say anything about it. You know, we have this guidance and this policy memorandum, and this is what they said last time. I get these very blank stares from the other side of the table, meaning, how can this be? Like, do you not have the law that provides the guideline? Well, we don't. I mean, our laws are very evolving, and we have common law, which means that litigation is where our law is actually crafted. And of course, in EB-5, it's so limited, so we don't.
In immigration, we don't have as much rulings. We have AO decisions that are not always
Absolutely.
published, or some of them are official.
Some of them
That's
are not
what makes
very
so
good.
key of communicating and talking with other immigration lawyers in this forum, because experience and seeing what the
Absolutely.
RFEs other people got and how they want it, and to kind of imitate and learn from those mistakes and to build on is key in our practice. It really is
Absolutely.
information and knowledge sharing that's going to make the difference for our clients and for our practices. Well, thank you, Belma. I appreciate you coming out today and talking with us about this issue.
Thank you for having me. I've really enjoyed it, and I look forward to continued discussion on the blog of the Immigration Lawyers podcast.
Thank you so much.
You're very welcome.
Thank you for listening. To learn more about this program, please visit www.immigrationlawyerspodcast.com. Also, attorneys can visit www.immigrationlawyerslistserv.com to learn more about special listservs for immigration lawyers that provide forums to discuss professional questions and issues and exchange information with other practitioners from across the globe.